Hey guys, so this is my third video for Constitutional Law 2, and today our topic will be about Section 5 of Article 3, still on the Bill of Rights of the 1987 Constitution. So what is Section 5? So in Section 5, it says that no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. No religious test shall be required for the exercise of civil or political rights. So first, we discuss what is religion. Religion is a profession of faith to an active power that binds and elevates man to his creator, and this concept is recognized. And insofar as it instills into the minds the purest principles of morality, its influences is deeply felt and highly appreciated. So what is the importance of religious freedom? The free exercise of religious profession or belief is superior to contract rights. In case of conflict, the latter must therefore yield to the former. Remember in our other video, there was I had an example that in balancing of interest test, whether the right to religion or the right to contract, which one weighs more, which is the more important right. And it says there that our right to religion is more important as one of our fundamental rights. So religious freedom, although not unlimited, is a fundamental personal right and liberty and has a preferred position in the hierarchy of values. It is only where unavoidably necessary to prevent an immediate and grave danger to the security and welfare of the community that infringement of religious freedom may be justified, and only to the smallest extent necessary to avoid danger. So what are the aspects of religious freedom? So we have here in the screen 5. So first is the principle of separation of church and the state. The separation of church and the state shall be inviolable. Second is the non-establishment clause. So no law shall be made respecting an establishment or religion. So third is the free exercise clause, wherein no law shall be made prohibiting the free exercise of religion, the free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. Then fourth, we have prohibition on religious test. So no religious test shall be required for the exercise of civil or political rights. And fifth, we have other constitutional prohibitions. So this includes no public money or property may be appropriated, applied, paid, or employed directly or indirectly for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion, or any priest, preacher, minister, other religious teacher, or other religious professionals, and as such to be described in this clause. So except the exception here is when such priest, preacher, minister, or those kind is assigned to the dignitary forces or to any penal institution or government orphanage. So we also have religious denominations and sects that cannot be registered as political parties or organizations. This is Article 9, Section 2, Paragraph 5. So in Article 2, in the Declaration of State Principles and Policies, the general rule in Section 6 states that the separation of church and the state shall be inviolable. So the prohibition expressed in Section 5 is a direct corollary of the principle of separation of the church and the state, without the necessity of adverting to the historical background of this principle in our country. It is sufficient to say that our history, not to speak of the history of mankind, has taught us that union of the church and the state is prejudicial to both, for occasions might arise when the state will use the church and the church the state as a weapon in the furtherance of their respective ends and aims. So all the officers of the government, from the highest to the lowest, in taking their oath to support and defend the Constitution, bind themselves to recognize and respect the constitutional guarantee of religious freedom with its inherent limitations and recognized implications. It should be stated that what is guaranteed by our Constitution is religious toleration. A creator is recognized by the Philippines as a people, as inferred from the preamble of the Constitution. So we have twin aspects of religious freedom. So first, we have the non-establishment of religion, or the Non-Establishment Clause. And the second is the free exercise of religion or the free exercise clause. In the first one, it says that the state cannot promote or establish any religion. And in the second one, the state cannot interfere with the exercise of religion. We will tackle this more on the later slides. So the nature and the relationship between aspects is that the constitutional inhibition on legislation on the subject of religion has a double aspect. On the one hand, it forestalls compulsion by law of the acceptance of any creed or practice of any form of worship, freedom from conscience, and freedom to adhere to such religious organization of form of worship as the individual may choose cannot be restricted by law. So, on the other hand, it safeguards the free exercise of the chosen form of religion. So the nature of the relational concept, because the term of the relation are not immobile concept. These terms are on one end the human experience expressed by the word religion, and on the other end the proper actions within the domain of the state. So it means that the two concepts come into conflict more often. So how do we distinguish if a case involves a free exercise case or a non-establishment case? It's said in the book of Bernas that every violation of the free exercise clause involves compulsion, whereas a violation of the non-establishment clause need not involve compulsion. So the exceptions here is where when there are certain general concessions which are indiscriminately accorded to religious sects and denominations. So the exemption from real property taxes is when charitable institutions, churches, convents, those types, mosques for the Muslims, and non-profit cemeteries, and all lands and improvements actually directly and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. The second is we have religious ministers may be assigned in certain public offices. Priest, teacher, minister, or dignitary may be assigned to the armed forces or to any penal institution or government orphanage, and public funds may be appropriated for such purpose. Then third, we have optional religious instruction may be taught in public schools. At the option expressed in writing by the parents or guardians, religion shall be allowed to be taught to their children or wards in public elementary and high school within the regular class hours by instructors designated or approved by the religious authorities of the religion to which the children or wards belong without additional cost to the government. Then we have religious holidays, Thursday and Friday of Holy Week. So we also have Thanksgiving Day, Christmas Day, and Sundays are made legal holidays in the revised administrative code because of the secular idea that their observance is conducive to beneficial moral results. And actually, recently we also celebrated the Eid al-Fitr, which is also considered a national holiday, and it's a holiday for the Muslims. Then we have certain crimes against religious worship that are penalized. So the law punishes polygamy and bigamy, and certain crimes against religious worship are considered crimes against the fundamental laws of the state. So we go now to the non-establishment clause. So the rule here is no law shall be made respecting an establishment of religion. So it basically prohibits the establishment of any religion by the state. Its essence is that the state cannot set up a church, neither can it pass laws which aid only one religion. So, or aids a lot of religions. So neither can open or secretly participate in the affairs of any religious groups and vice versa. The clause against establishment of religion by law was intended to erect a wall of separation between the church and the state. While there is no unanimity in the interpretation of the non-establishment clause as a political principle, there is substantial agreement on the values the non-establishment clause seeks to protect. So there are two. First is voluntarism, and the second is insulation of the political process from interfaith dissension. So in the first one, as a value is both personal and social. A personal value is nothing more than the inviolability of the human conscience, which is also protected by the free exercise clause. As a social value, Protected by the Non-Establishment Clause, it means that the growth of a religious sect as a social force must come from the voluntary support of its members because of the belief that both spiritual and secular society will benefit if religions are allowed to compete on their own intrinsic merit without benefit of official patronage. So in the second one, voluntarism cannot be achieved unless the political process is insulated from religion and unless religion is insulated from politics. Non-establishment assures that insulation and thereby prevents interfaith dissension. So the Non-Establishment Clause states that the state cannot set up a church, it cannot pass laws which aid one or all religions or prefer one over another. Third, the state cannot influence a person to go or to stay away from church against his will, for to force him to profess a belief or disbelief in any religion. So what are the exemptions here? So we have tax exemptions on property, actually directly and exclusively used for religious purposes. Second is citizenship requirement of ownership of educational institutions, except those established by religious groups and mission boards. Third is optional religious instruction in public elementary and high schools at the option expressed in writing by the parents or guardians. Religious instruction taught within regular class hours by instructors designated or approved by the religious authorities of the religion to which the children or wards belong without additional costs to the government. Fourth, the appropriation allowed where the minister or ecclesiastic is employed in the armed forces, in a penal institution, or in a government-owned orphanage. Fifth is government sponsorship of town fiestas. Some purely religious traditions have now been considered as having acquired secular character, like the Sinulog, the Santo Niño Festival. Sixth is the postage stamps depicting Philippines as the venue of a significant religious event. Benefit to the religious sect involved was merely incidental, as the promotion of the Philippines as a tourist destination was the primary objective. This was in one case discussed in our class. So what are the tests applied to determine violations of the Non-Establishment Clause? So we have the lemon test, the strict neutrality or separation test, benevolent neutrality or accommodation test. So we go now to the first one. In the lemon test, it is a test to determine whether an act of the government violates the Non-Establishment Clause. So to pass the lemon test, a government act or policy must first have a secular purpose, second, not promote or favor any set of religious beliefs or religion generally, and third, not to get government too closely involved or entangled with religion. So in the second test, in the strict neutrality or separation test, it examines only whether the government action is for a secular purpose and does not consider inadvertent burden of religious exercise, a rigid reading of the principle of separation between church and the state. So this was in the case of Estrada versus Escritor. Then the third one is benevolent neutrality or accommodation, an approach that looks further than the secular purposes of government and examines the effect of these actions on religious exercise. The court will strive to accommodate religious beliefs and practices when it can within flexible constitutional limits. The Philippines adheres to this. This was also stated in the case of Estrada versus Escritor, because in that case, Escritor was a woman and she had a position in the judiciary, and so she in her religion, in the Jehovah's Witnesses, they were allowed she was living with her partner, and they were both married, and before she got widowed, they said that by their religion, the union of the two were allowed. So these tests were applied in that, and in the end, the Supreme Court used this benevolent neutrality or accommodation test, in which this approach gives room for accommodation of religious exercises, provided that it does not offend compelling state interest. So the cases where government aid violates the Non-Establishment Clause. So we have state-sponsored Bible. So these are the cases where government aid violates the Non-Establishment Clause. So first, we have state-sponsored Bible readings and prayers in public schools. So there is no secular purpose here. Second is salary payments and reimbursements for secular textbooks and other instructional materials under a system involving close government supervision. There is excessive entanglement between the government and the recipient institutions. This was in the case of Lemon versus Kurtzman, which also brought about the Lemon test. Then we have the cases where government aid does not violate the non-establishment clause. So we have tax exemption, operation of sectarian schools, religious instruction in public schools. Then we have public aid to religion in Section 29, Article 6. So the cases is when the postage stamps depicted the Philippines as a site of religious event. As I said a while ago, we discussed this in class. Wherein in the case of Agrippa versus Ruiz, wherein postage stamps which promote a Catholic event are constitutional because it only showed tourism for the Philippines. It showed that Manila is the capital of the Philippines and they wanted to boost tourism in the Philippines. So another is government sponsorship of town fiesta. A fiesta is social religious affair. Its celebration is an ingrained tradition in rural communities rather. The fiesta relieves the monotony and drudgery of the lives of the masses. Like what I said a while ago, the Sinulog Festival. Book lending program for students in parochial schools. The benefit redounds to students and parents and not any particular sect. Display of crèche in secular setting. Crèche is displayed in a secular manner and merely depicts the origin of the holiday. The Constitution mandates accommodation and not merely tolerance instead of an absolutist approach. Court inquires if the law or conduct has a secular purpose. Then we have financial support for secular academic facilities. An exemption from zoning requirements to accommodate architectural features of religious buildings. Then we have celebration of religious holidays, the expropriation of the birthplace of Felix Y. Manalo. This was an interesting case in Manosca versus Court of Appeals. I also mentioned this in my other video. It says there that the place where Manalo was born became a historical landmark, and I think the Manosco, which owned the land, were protesting that that it violates the Equal Protection Clause, but it does not because it violates the eminent domain, but it does not because it was for public use, even if it's only for the INC members. So we also have the free exercise. We go now to the free exercise clause, or the freedom of worship and belief. The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. It has a dual aspect. So the free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. The constitutional inhibition on legislation on the subject of religion has a double aspect. On one hand, it forestalls compulsion by law, by the acceptance of any creed of the practice of any form of worship, freedom of conscience, and freedom to adhere to such religious organization or form of worship as the individual may choose cannot be restricted by law. On the other hand, it safeguards the free exercise of the chosen form of religion. Thus, the amendment embraces two concepts, the freedom to believe and the freedom to act. The first is absolute, but in the nature of things, the second cannot be. So is the government absolutely prohibited from interfering with the exercise of religion? So the answer is no. The government may exceptionally interfere with religious acts and exercises if there is a clear and present danger or there are compelling state interests involved. It does not follow that because no mode of worship can be established or religious tenets enforced in this country, therefore any tenet, however destructive or of society, may be held and advocated if asserted to be part of the religious doctrine and of those advocating and practicing them. While legislation for the establishment of religion is forbidden and its free exercise is permitted, it does not follow that everything which may be so called can be tolerated. Crime is not the less odious because sanctioned by what any particular sect may designate as religion, whether an act is immoral within the meaning of the statute, is not determined by the accused concept of morality. Congress has provided the standard. The offense is complete if the accused intended to perform and did not in fact perform the act which the statute condemns. So the two aspects we talked about a while ago is the freedom to believe, which is absolute, and the other one is the freedom to act on one's belief. So we go now to the first one. It is absolute as long as it is not as it is confined in the realm of thought. This carries with it the corollary expectation that the government, while it may look into the good of a person, cannot inquire into a person's religious pretensions. The individual is free to believe or disbelieve as he pleases concerning the hereafter. He may indulge in his own theories about life and death, worship, and any god he chooses, or none at all, embrace or reject any religion, acknowledge the divinity of God or of any being that appeals to his reverence, recognize or deny the immorality of his soul, in fact, cherishes any religious conviction as he and he alone sees fit. However, absurd his beliefs may be to others, even if they be hostile and heretical to the majority, he has full freedom to believe as it pleases, because even some people are considered atheists. For us Catholics, it may not be right, but it's their freedom of religion to choose. So he may not be required to prove his beliefs. He may not be punished for his inability to not to do so. Religion, after all, is a matter of faith. Men may believe what they cannot prove. Everyone has a right to his beliefs, and he may not be called to account because he cannot prove what he believes. So, on the second aspect is the freedom to act on one's belief. This is subject to regulation. It is subject to regulation where the belief is translated into external acts that affect the public welfare. The moment belief follows into action, it becomes subject to government regulation, where the individual externalizes his beliefs in acts or omissions that affect the public. His freedom to do so becomes subject to the authority of the state. As great as this liberty may be, religious freedom, like all other rights guaranteed in the Constitution, can be enjoyed only with a proper regard for the rights of the others. It is error to think that the mere invocation of religious freedom will stalemate the state and render it impotent in protecting the general welfare. The inherent police power can be exercised to prevent religious practices inimical to society. And this is true even if such practices are pursued out of sincere religious conviction and not merely for the purpose of evading the reasonable requirements or prohibitions of the law. So this was stated in the case of in request of the Muslim employees. They were requesting in that case for their work hours to be from 7:30 to 3:30 during the Ramadan period, and also giving them time for their religious worship during Fridays. But the Supreme Court granted the first one but denied the second one. So we also have the clear and present danger tests. These are the tests applied to determine violations of the free exercise clause. The clear and present danger tests. We have compelling state interest test. So in the first one, in the clear and present danger test, whether government interference is justified by the existence of a clear and present danger of a substantive evil that the state has the right to prevent. We have already discussed this also in our previous videos. So the second one is the compelling state interest tests. So we have the requisites here. In order to interfere with religious exercise, the court should look into the sincerity of religious belief without inquiring into the truth of the belief. Second, the state has to establish that its purposes are legitimate and compelling enough to override such religious belief and practice. Third is the state must use the least intrusive and restrictive means. So the cases where the government interference violates the free exercise clause. So we have in Ebralinag versus Division Superintendent of Schools, wherein to compel students to take part in a flag ceremony when it is against their religious belief will violate their religious freedom. So in this case, the kids and the teachers were members of the Jehovah's Witnesses, and they saw the flag of the Philippines as something of an idol, and it's against their religious belief. And they were exempted from attending because they said in that case that they weren't doing anything also to promote disrespect for the flag. So another is to deprive Muslim group of the power to certify food as halal that is suitable for consumption by Muslims according to their religious belief, and giving such task to a government agency. Another is to interfere with the issue of expulsion or excommunication of a member from a church. Then we also have the state requiring a license for the dissemination of religious literature. Then the state compelling Amish teenagers to go to high school where the Amish belief has a system of informational education which ensures the physical and mental welfare of the child and prepares him to discharge the duties and responsibilities of citizenship violates free exercise of religion. So we also have cases where government interference does not violate the free exercise clause. So we have in the case of Tolentino versus the Secretary of Finance, wherein the sale of religious literature, books, etc., is subject to VAT, and the religious institution may be compelled to register as a VAT taxpayer and to pay the cost of such registration. Then we have the solicitation of contributions in general, which may include contributions for religious purposes, may be regulated by general law for the protection of the public. Then we have prohibition on religious tests. The rule here is that no religious test shall be required for the exercise of civil or political rights. The rationale for this rule is the purpose of the prohibition on religious tests is but a corollary of the freedom and non-establishment clause, is to render the government powerless to restore the historically and constitutional discredited policy of probing religious beliefs by test oaths or limiting public offices to persons who have or perhaps kind of religious concept. To allow religious tests would have the effect of formal or practical establishment of a particular religious faith with consequent burdens imposed on the free exercise of the rights of non-favored believers. Then we have the conscientious objector test. This test is applied in the US to avail of an exemption from military service based on a law which provides that persons who are conscientiously opposed to participation in war in any form of reason of religious training and belief may be exempted from combatant training and service in the armed forces. So the requisites that is that there must be belief in God or some parallel belief that occupies a central place in the believer's life. The religion must involve a moral code transcending individual belief. Third is it a demonstrable sincerity in belief is necessary, but the court must not inquire into the truth or reasonableness of the belief. There must be some associational ties, although there is also view that religious belief held by a single person, rather than being part of the teachings of any kind of group or sect, are entitled to the protection of the free exercise clause. And we have the anti-evolution of laws. So here, the anti-evolution statute, which was said in the case of Epperson versus Arkansas. The appellant Epperson, an Arkansas public school teacher, brought this action for declaratory and injunctive relief, challenging the constitutionality of the Arkansas anti-evolution statute. That statute makes it unlawful for a teacher in any state supported school or university to teach or to use a textbook that teaches that mankind ascended and descended from a lower order of animals. So this is the Charles Darwin. The state Chancery Court held that the statute an abridgment of free speech violating the First and 14th Amendments of the United States. The state Supreme Court, expressing no opinion as to whether the statute prohibits explanation of the theory or only teaching that the theory is true, reversed the Chancery Court. In a two-sentence opinion, it sustained the statute as within the state's power to specify the public school curriculum. So it was held in this case that the statute violates the 14th Amendment, which embraces the First Amendment's prohibition of state laws respecting an establishment of religion. So that ends our topic for section 5. Thank you for listening, and I hope this helps your review for constitutional law 2.